Well, good morning, everyone. We came on screen slightly late due to the 1 minute silence for COVID frontline workers. And our apologies for that. So welcome to Terra Firma Chamber's first webinar. We currently have roughly 150 people listening, which is slightly awe-inspiring, but hopefully we will be able to run a seminar for you. Has provided there are a plethora of new rules and guidance and challenges to deal with it. Today we have chosen 5 topics to focus on to give a short overview of the issues that you in local government may be facing and others involved with local government may be facing, and to provide some suggestions or pointers as to how it may work in the future. We're proposing to have 10 minutes on each, and there will be questions, time for some questions at the end, we hope, and there's a question and answer function on your screen which you should be able to use. The slides will be available at the end, but on request, and the last slide will show you the contact details. So without further ado, I'm going to pass over to Maurice O'Carroll, who's going to talk about conducting and the problems of conducting public inquiries in the times of coronavirus. Thank you, Maurice.
Thank you, James. Next slide, please. Now, with my apologies to Gabriel Garcia Marquez for the title, you'll see behind me I've got a virtual picture of the Advocates Library, which is of course a photograph, not in fact where I am, but I think in real life that's pretty much what it would look like right now. I'm moving on first to my first slide to a survey that was carried out in the Planning Bulletin just last week, and the headline was "Planners Concerned About Delays to the System." Obviously this is something that is quite universal anyway. And we have some responses there which they set out that 96% of respondents have moved to remote working, and that 65% of them have closed their offices completely, and that 52% of them favour digital hearings, inquiries, local review bodies and planning examinations. Now I'm going to focus mostly on the question of inquiries, and in relation to the response that are there, it might be thought, if you were being a bit flippant, that 48% of people were quite happy for things to be in lockdown and for things never to change. But in fact, I think, judging by the headline, and I think obviously of our own experience in the Court of Session, Sheriff Courts and in the Inner House, matters are different, and the attitude is quite different, and basically progress must require to be made. Next slide, please. So I've taken these issues with regard to remote operations which I've distilled from an inquiry that I'm involved in, and also in fact James is also involved in, and I've distilled a short number of the points that were raised with regard to the notion of remote working. The first and foremost is what you'd expect all lawyers to focus upon, is that there is a legal right, certainly in terms of the Electricity Act 1989, to have an inquiry. There was difficulties concerned with regard to the complexity of them, participation by members of the public, reliability of the technology, possibility of things going wrong, and the need for proceedings to be conducted with appropriate rigour suitable for planning inquiries. And finally, what has actually been something of a game changer at the moment, at least, is site inspections. If I could go to the next slide, please. Now, with regard to this, there is, as has been said, a plethora of guidance and new initiatives that have come out very hurriedly, as you'd expect, with regard to providing solutions to these problems and others. The first one is the legislative setup, which will change things, such as, for example, pre-inquiry meetings, which are now completely suspended. But there is also, of more relevance to what I'm discussing, the DPEA guidance note on those matters, which was issued on the 24th of March. The main point to obtain from that is that in all cases, what the DPA will do is to go to the written procedure, to use written procedure as a default position for all work, and to make progress wherever possible on all matters that can be dealt with by written procedure as opposed to oral procedure. That will include most matters with the exception of potentially inquiries. So none of those are taking place at the moment. Then there is perhaps the prospect of the introduction of a new employee known as the program officer, who can assist with the conducting of virtual inquiries, if indeed that is what is then to be the future way of progressing matters in future. It is accepted by the DPA, as you'll see from the third last bullet point, that inquiries themselves present particular challenges over pre-inquiry meetings and hearings, which are essentially can be done by way of, if you like, speeches from the parties involved with that, by reference to particular cases, case law, and productions. But where you're dealing with matters such as examination in chief, cross-examination, and re-examination of witnesses at a remote location, those present particularly difficult problems, and one wonders with regard to the solution to that, and I'll be coming back to that later. The other major issue has, of course, been site visits, and that has been a primary cause for suspension, at least in part, of the inquiry that I'm currently involved with. And at the moment, there are none. James has been good enough to draw my attention to guidance that has been issued in England by Natural England with regard to whether or not there can be site inspections or field work, as it's called, but in the time of a lockdown. And the general overall guidance is that these can be carried out so long as the other guidelines, such as social distancing, can be adhered to. The other solution that has been suggested as well is there is a possibility of simply using plans and photographic evidence that's already been submitted as part of the inquiry documentation, or alternatively a Zoom or other video meeting at the site itself. Equally, the DPA guidance not understandably focuses on and recognizes the importance of local participation, which is of course one of the major issues that were raised at the other inquiries I've mentioned already. And it is a matter of importance. Obviously, it's a public local inquiry with the emphasis on the word public. But I think a phrase there is something perhaps James would like me to point out, is that in essence, a public local inquiry is a hearing in public and not a public hearing, and perhaps an important distinction. So to that end, since we have the benefit of technology now, an awful lot of the issues with regard to public involvement can be overcome by widespread or universal use of webcasting and documents where they require to be looked at, instead of the public set being available at inquiries, will in fact also be available simply on the DPEA website for members of the public to look at, and therefore to be aware and to be apprised of the documents that are to be considered during the course of the public inquiry. Next slide, please. So what we're left with then is really the matter of the next steps. In terms of the guidance, I've raised a couple of other matters. There's guidance all over. The top one there is actually Irish guidance, and the one underneath that is what I thought would be interesting to draw attention to is international guidance, because when you're dealing with international arbitrations, by definition, those are procedures that have their genesis where parties are remote from each other in order to conduct the business of the tribunal at a great distance, and so therefore there is a large body of experience which informs that particular guidance and is of course of relevance here. The other matters that I'd then like to raise in closing is that we have already had the experience of the Court of Session getting up and running again. And in the case of Stuart Campbell against Kezia Dugdale, that was successfully heard in the appeal court of the Court of Session at the beginning of last week. But I would then also mention that there is the resistance to certain matters which have an intensely public forum, which involve members of the public, which has been perhaps exemplarized by the Criminal Bar Association's resistance to the temporary suspension of jury trials. One thing I would note is that very often these temporary measures have a habit of becoming permanent. And the example there is of the diplock courts introduced in Northern Ireland, which started in the 70s and didn't end until some 30, 40 years later, are in fact still, theoretically possible. So whilst there is an acknowledgement that the public local inquiry is a legal entitlement, there is also a notion that there might be a waiver of that particular public right in person, so long as procedural fairness and transparency can be guaranteed. In which case, I would say that my own experience is that, particularly with landscape witnesses, that trying to pin down landscape witnesses, and some in particular I can think of, is like nailing the proverbial jelly to a wall, and is something that is very difficult to do, and certainly quite difficult, I would have thought, at a distance. It is true that we as lawyers and participants should focus on more focused and tight questioning. However, there are perhaps some questions that are perhaps more nuanced, requiring a greater degree of discussion and preamble before they can actually make sense. And finally, in closing, there is the other notion, I think, perhaps for discussion, as to whether or not the inquiry actually should now mean, or be interpreted to mean, something that is in a physical location, or perhaps really this is the way forward. And if we are to continue, we must simply find a way through the present situation now that we're required to do things at a distance. So with that very brief run through of the situation with regards to inquiries in particular, I now move on then. Can I now just introduce Fred McIntosh, QC of Terra Firma Chambers, who will now take over. Fred will need to unmute.
Thank you, Maurice. This section is attempting to focus on a part of the UK emergency legislation which tries to recognise that delivering complex local government services is difficult in this time of COVID-19. Next slide, please, Emma. I wanted to look at section 16 and 17 of the 2020 Act, which commenced on the 5th of April. It's worth having the legislation in front of you when you're thinking about how it actually works, but just at the overarching level, it's worth noticing what it does is it enables a local authority to avoid meeting various statutory duties related to community care. Now, the most obvious one is, and I'll come to the full list in a moment, is section 12A of the 68 Act. But in all cases, what the provisions of section 16 allow the local authority to do is to consider whether it will be practical to comply with that duty and whether it would cause unnecessary delay in providing community care services, not just in most cases to the subject of the possible assessment, but wider groups of people, including in some cases any person. And it gives a discretion to the local authority to decide not to comply with the duty. So the factors vary slightly between the duties, but they all seem to be focusing on giving a measure of discretion to local authorities. Now, the question will be, is it actually helpful? And what factors can you consider when making this assessment? There are clearly two listed in section 16, but it might be worth observing that I rather suspect that we haven't got any money. So let's not comply with the duties is not going to be a relevant consideration. Next slide, please. So this is just a list of the slides of the duties that are mentioned in section 16. I won't go through them all in detail. You can see that most of them relate to carers, but there's a wide range of them. The second one's quite interesting because it enables the general principles in provision of social care not to be complied with. And looking at those principles, I do wonder whether they are there to enable an assessment to be carried out, but without the need to ask the person who is the subject of the assessment what views they might have. Next slide, please. But of course, there are still requirements that support must be provided. Now, in two particular areas that relate to carers and formerly looked after young people, the Act is clear that the local authorities need to continue to provide support. And of course, the general enabling power to provide community care without assessment in the 68 Act still exists. Next slide, please. Now, it's worth, next slide, please. It's worth just quibbling a little bit here at various things. There is Scottish Government guidance, which of course councils must comply with. But the guidance talks about partial assessments. And one reading of section 16 is that's not really how it's written, but ultimately the guidance will have to be complied with. The most interesting area is in respect of charging, because authorities are obviously required since Avon County Council against Hooper back in the 90s to act reasonably in deciding to charge retrospectively to recover costs. Now, section 17 of the 2020 Act allows councils to carry out an assessment later when it becomes possible to do so, and then to recover charges. I do wonder whether there's an issue about reasonableness, about when it's appropriate to carry out such an assessment, because we have to anticipate in this emergency there's going to be a period when we began to gradually reopen. And so decisions not to carry out assessment perhaps are easy to make now, might become more nuanced and more difficult in individual cases as we run through the late summer and autumn of this year. Now, can we move on to the next slide, please? Next slide, please. Thank you. Now, this is a little bit tinfoil hat, I accept, but the odd thing is that this legislation was put through the Westminster Act, which rather makes it harder to judicially review it, of course. And it's worth remembering that there is no derogation in this emergency from the Convention. And Section 6 of the Human Rights Act still applies to local authorities. Now, of course, it's well known that attempting to leverage in claims under Articles 2, 3, 8, and 14 of the Convention into social care cases is extremely difficult, there being no convention right to community care. But if we think about the worst excesses of failures to care for people, and perhaps entirely a different topic, the case of Pretty against the United Kingdom, which was a right to die case, and we think about how degradation and diminishing someone's human dignity can result in an Article 3 claim, it is probably worth remembering that local authorities still have to meet those very low or very high thresholds to protect themselves against convention claims and, of course, public opprobrium. There are ministerial guidelines published. They're worth reading. The whole Act is worth reading, but I hope that's been a useful canter through this area. And it's worth saying that in the months to come, local government will probably be discussing these rules and when to cease applying them and how to recover the money. And for that purpose, I'll turn over to James Finley QC. He's going to talk about local government virtual meetings. Thank you.
Thank you, Fred. My 10 minutes this morning is going to be about virtual meetings. And it's a problem that's faced local authorities up and down the country about how to have a meeting about anything when you cannot be in the same room. Scotland has the advantage over England in that it already on the statute book was section 43 of the Local Government in Scotland Act 2003, which made provision for remote meetings. England and Wales had to introduce flexibility regulations at the beginning of April. First point to note about section 43 is it covers all meetings. Second is it allows remote participation. And the third point is that the only requirement is that each member must be able to participate in the meeting. Now, in England and Wales, the flexibility regulations require that a member can speak and be heard, and if possible, seen. There's no such guidance in Scotland. The simple requirement is that of participation. And the Act doesn't say anything about the public, but it must be assumed that they can remotely participate too. So it is a very broad power, but there are no parameters about how it will be exercised. I've put on this screen under powers two other provisions which will be relevant. Firstly, Schedule 6 of the Coronavirus Act covers a number of matters, but it makes provision for exclusion of public from local authority meetings. Now, whilst that may not be relevant at the moment, it may be something that, as lockdown is eased, that may come to the fore. And lastly, the Town and Country Planning, Miscellaneous Temporary Modifications, Coronavirus Scotland regulations. All coronavirus regulations seem to be a particular mouthful. That makes it clear that local review bodies no longer need to operate in public. It also, just to note, whilst I'm mentioning the change to the regulations, to the 2003 regulations, which make provision for that, planning schemes of delegation need ministerial approval, and ministers have indicated that they will speedily approve any changes to planning scheme of delegations that are required to cope with the current crisis. So moving from that on to what guidance or protocols are currently available. Angus Council had I think it was possibly the first full virtual council meeting on the 3rd of April of this year. And at that meeting, all members and the public attended virtually. I believe it was on Zoom, a point I'll come to in a moment. And at that meeting, the council passed changes both to its constitution and its standing orders to provide for more efficient working of the council during the COVID crisis. Now, I know many other councils in Scotland have simply cancelled all meetings, but it is a working example of a full council meeting that has occurred and successfully met, and indeed other meetings of Angus Council are occurring and other meetings of other councils occurring. For instance, I understand Aberdeen Shire Council has had planning meetings. So if one is considering what type of changes to standing orders or how they did it, there are on Angus's website the full minutes of the meeting as you would expect and the papers that go with it, and they're a useful resource. Secondly, Highland Council has published a video conferencing protocol. It has, not surprisingly, had members that can be some removed from Inverness or wherever the meeting is going to take place. And it is a very good illustration of working through the practical problems of what happens if you lose contact with somebody, or if, apparently as I may be at the moment, suffering from rural broadband and not being particularly well heard. Two other or three other publications from down south which may be of assistance. The Association of Democratic Service Officers, which I've spelt incorrectly, and Lawyers in Local Government have produced a remote meetings protocol and procedure rules, and I've given you the website link. And for those practicing in licensing law, there's the Institute of Licensing has produced a protocol, Annex 1 of which deals with remote hearings. So again, there's a useful resource there if you're thinking about how to run a remote meeting. And then last but not least, Cornerstone Barristers, and I practice in England as well as in Scotland, have produced 2 webinars and some FAQs on running remote meetings. As I indicated at the outset, there are different regulations there, but in essence, the problems are going to be the same. I should say that there are other chambers available in England, but I wouldn't necessarily recommend them. So those are the rules, the guidance and the protocol that are available. What are the issues that may arise? So the first issue is which platform to use, and there's a reluctance to use Zoom, but as I said, I believe Angus Council is using Zoom, and in England, a number of councils are using Zoom, and indeed we're using Zoom today. It has some problems, apparently with security, but for public meetings that should not be a particular issue. Other authorities have used Skype or Microsoft Meetings. A telephone option is something that might be considered. For those who apparently or who may not be able to access broadband. So it may be that both a telephone option and an internet option should be made available to ensure that public, if the public are involved, that can be successfully heard. Then there are queries about to be heard or not seen. Do all members need to be on the screen at the same time, for instance? Who should appear on the screen? Should it be the chair and the advisors? Should it just be the speaker? How you should deal with gallery and speaker view? Those are issues that will need to be worked out by the council. There is definitely, in my view, a need for protocols. The how the chair will conduct a meeting, what changes to a member's behaviour will be required in order that the meeting can proceed effectively and efficiently, how people can indicate if they want to speak, how you can provide, if appropriate, for interruptions or controls. They can all be set down in protocols so that members can see them in advance. What to happen, for instance, if the chair suddenly becomes unavailable. In this case, Fred would take over from me. Practice can make perfect. We shall see whether we get to the end of this seminar without a serious hitch. Those are all the types of things that have to be considered. Moving on to that, there are members' computers and skills. No doubt those are practical problems that will have to be dealt with. And then entitlements to speak. Many standing orders and constitutions provide in particular spheres the right of persons to speak and address the committee, even if for limited periods of time. The new legislation doesn't do away with those rights, so that they have to be either catered for within your protocol, or if you are amending your standing orders or your constitution, you have to provide for them. Another factor is, should the council be seeking or providing assistance for those that need to join meetings? And that, for the normal member of the public, that may not be a major issue. But if someone is facing the loss of a license, but they don't have access to the internet, that's something that, in order that the meeting be fair and the hearing be fair, if it's a hearing, for instance, a licensing hearing that's taking place, that's something that the council should think about. Voting and quorums are another issue. Let me give you an example from a local authority down south. A contentious planning decision, full debate online, agreed beforehand that they would take the vote orally. So they ran through each councillor, but by the time they got to the last councillor, he had muted himself and was unable to unmute himself. What should the chair do? The councillor could fortunately hear them. So when the committee clerk said, "Are you voting for or against the proposal?" he held up a piece of paper which said "for." And so there could really be no doubt as to what his intention was, even though under the English regulations, he was required to be heard. The courts, if faced with a challenge as to the conduct of a meeting, are, in my view, likely to be very lenient, provided the council has done its best to ensure fairness and appropriate action. Provision of papers is something that will have to be considered. Exclusion of the public and members' interests. The public may be needed to exclude if you've got confidential items. members may have to exclude themselves if they've got an interest in the proceedings. And remember, when a member excludes themselves, they have to leave the room physically, which means they have to leave the meeting virtually. Otherwise, their presence could be said to impact on those still taking part. There have to be provision for dealing with disruption at meetings. For all those reasons, the protocol will be vital. Lastly, down south, there was some suggestion that meetings should deal with urgent items only. You can deal with all items under the Local Government in Scotland Act 2003, but the type of item that is dealt with will very much be dictated by the current crisis. So that's a very quick speed through the issues of virtual meetings. As I say, there's much more assistance in the documents I've referred to. And I'm now going to pass over to Peter Grant Hutchison, who's going to talk about working from home and resources and employment. Peter, thank you.
Thank you very much, James. Good morning. I'm going to talk a little bit about working from home and employment law and how the two interact. But I must say, I've got to reflect a little. When I put that cartoon in, you see the gentleman having a small sleep there, that was put in as actually a wind-up because my practice manager and my clerks all work from home, as we're all doing, of course, and it backfired because I see my practice manager put the gentleman sleeping from home immediately under my name. But it's also a cause for reflection as well. It makes you wonder how much control an employer ever has over employees when they work from home. And if any advocate thinks that they have control over their clerks, I must say that is purely illusionary. But it is a serious matter. The challenges and stresses of working from home, particularly at a time of lockdown, are considerable. But the law's the same. There's no allowances, no changes in relation to the law. Can I have the next slide, please? Thank you. Now, it all starts with the 1974 Act, which is a criminal statute. And that act says that an employer should take care of the welfare, health, and safety of their employees as far as reasonably practicable. And that is the authority for the promulgation of all the regulations that we see there. But of course, the regulations are there for a somewhat different purpose. Most of these regulations were there to implement European directives on health and safety and in terms of equipment. The first one emphasises, that's B, Management of Health and Safety at Work, emphasises the need for a suitable and sufficient risk assessment. And that's very important, and it'll feature a lot of what I'm going to say in the next few minutes. But I may say that we were talking about homework, and it's very recent, and it may not be of a huge duration. It may be sufficient to satisfy that if there's simply a phone call and you actually interrelate or discuss matters with your employee over the phone. The provision of use of work equipment regulations covers all the things that we think about in terms of display screens and computers, adequate lighting, ergonomically efficient seating arrangements. Health and safety regulations, well, it is homework is meant to be low risk, but you still have to have a discussion with your employees about the nature of any risk. It may be that you're talking about a health and safety, well, a first aid kit or something like that. The requirements may be quite small. And of course, lastly, is the requirement to report any serious accidents. But taken together, they focus on relating to your employees and discussing their concerns and the risk to them, whether it be through mental health, through stress at work, the need for adequate breaks, all of these concerns. But This is a list which you would normally expect to see when somebody's discussing personal injuries. Why are we discussing them in the context of employment law? Well, sometime further down the line, we may see claims arising about what's happening now. And the claims that we may see may be unfair constructive dismissal cases, where employment tribunals have to look and see what was the employer's obligations and how did he breach them. We may see whistleblowing cases. We may see reasonable adjustment, failure to make reasonable adjustment for people that are disabled. That's a form of disability discrimination case, and they'll be looking at what happened at the workplace. We also may see working time regulation cases, because somebody hasn't been taking breaks, the employer hasn't told them to take breaks while working from home. So we have all these potential cases. And I want to mention one authority in passing. It's not on the screen, but it is Kennedy v. Cordia, Kennedy v. Cordia 2016, One Weekly Law Reports. It's a Supreme Court case, and it was all primarily about the use of expert witnesses. But it was a care worker who was traveling to work and to give care. And it's interesting because in that case, the Supreme Court said the regulations apply throughout the time she was in the course of her employment. Not when she was doing the work, but throughout the time she was in the course of her employment. How does that apply to somebody working from home? And this comes to the question of, should there be core hours, necessary breaks, set times? Anyway, we now know the obligations and what must be done. Are the resources there to do them? Can I have the next slide, please? Of course, it is the age of austerity has ended, and we are now in new and halcyon days. Money is no object. Can I have the next slide, please? We all know that's not true. We all know that resources will not be there to temper these legal obligations. Now, that's a potential defence in some areas. It's not, of course, to Equal Pay Act cases, and it's rarely a defence in personal injury cases. Might be in terms of some areas of employment law. What do we do to try when things go wrong and we have problems making the adjustments? Can I have the next slide? Well, the first stage is when we're moving towards home working, you must consider the question of consulting with health and safety representatives. Is it a direct follow-on from the 74 Act, which I say is a criminal statute? And you must consult with health and safety representatives when there's going to be significant changes which may imperil health and safety. We're used to dealing with that when it comes to, let's say, freezing recruitment. But I suggest that we're making a substantial change to working from home. You must consult. Thereafter, I mentioned the case of Wigan Borough Council, which was the start of saying, well, yes, there is an implied term to give support to people to discharge their duties. That was a harassment case, but it's been since cited in many other situations to say, give them the correct tools, give them the support, give them the strategies. In Gibson, which we see next, the Employment Tribunal said, yes, but it's more important in safety cases. Employers give the right equipment when safety is at risk. And then I mentioned the case of Lassie. Now, in Lassie, the EAT said, we don't have to be concerned about implied terms because you promised to give the appropriate equipment. So beware what you promise, because you will be held to account in an employment law setting. Right, you know your obligations. What else will the tribunals do if you're in breach? It's purely impressionistic, but since about 2016, when you look at the cases, I get the impression that employment tribunals, appeal tribunals did get the message. They understood that there were scarce resources, and that has affected what has been reasonably practicable, and it affects the question of proportionality when we're talking about discrimination cases. So things got a bit easier for the employers. But what happens when you've done your best and everything goes really badly? Now, I've not mentioned this case in the list, but there's a case of Dr. Werner against Southampton University, a lovely case. The doctor made a claim for unfair dismissal and all sorts of discrimination, every type of discrimination you can imagine, from religious discrimination to race discrimination. And the legal department of the university failed to respond. They got an extension to respond. They got a second extension to respond. By February 2019, not responded, and the case in May proceeded to a remedies hearing in their absence, and an award was made of £3.5 million. They appealed, or didn't appeal, they asked for a further extension. Did they get it? Well, actually, they did. They said their legal team was under-resourced, overwhelmed, and things, and I quote this, things had gone to pot. On that basis, they got their extension, but we cannot rely on the system being that liberal in future. That is a situation to avoid. So when the worst comes to the worst, homeworking doesn't work, you might have mass redundancies, and I've quoted the case of Eton Limited v King and its sister case, King v Eton. I was in both of them. They are the lead cases on Scotland on consultation and mass redundancies. I hope it doesn't come to that. Keep safe and please keep your jobs. And I would pass on to Robert Skinner.
Well, thank you, Peter. I think when Emma asked me to give the talk on licensing update, I thought that this might be the shortest talk in history, because you all know that pubs and clubs have now closed. So I would simply say that nothing's happening. I'll see you next year when they reopen, and stay safe. But we know that all those involved in the license trade know that the government are always fretting about Scotland's unhealthy relationship with alcohol. And ironically, the coronavirus may have done what the current government is tried to be doing for over a decade, namely to slim down considerably the Scottish licence trade. But of course, life is never as simple as that. And in a crisis, the machinery of government can move with impressive speed. They have passed the Coronavirus Scotland Act of 2020, and that has made a number of amendments to the Licensing Scotland Act to allow for the difficulties caused by the lockdown. These conveniently are all contained in Schedule 5. I've had a look through these, and what I can say with certainty is that they are tedious beyond belief. But what I can also say is that they tend to apply where something can't be done for a reason due to coronavirus. So it's likely that these provisions will not survive the present epidemic. Essentially, they're all pragmatic measures to try to get through this. And of course, pubs and clubs are likely to be the last premises to be allowed to reopen once the lockdown eases. So they may have effect for a long time, probably till the end of this year, perhaps the beginning of next. I'm unable to go through all of these due to the length of them. But what I can give you is perhaps a few edited highlights. Provision is made for the first time for remote hearings, and we've heard quite a lot about that from my colleagues this morning. Where there is a necessity to hold a hearing, for instance, where an application is made and that is objected to, this can be done remotely, again, because of a reason related to coronavirus. Remote hearings can be done by telephone, written communication, or video conference. To date, so far as I'm aware, these hearings have been few and far between, and they are unlikely to be convened unless there is a grave urgency. And such urgency, of course, is likely to be few and far between because the premises are shut. Now, as we've heard, I think, from Maurice this morning, video conferences have been trailed in the course of session, apparently with some success. Now, it's all a matter of personal opinion. I'm not a fan of video conferencing or hearings that way, and not least because you've got to be careful to mute your mic so that not everyone hears my witty aside and the quality of my opponent's submission. And the other thing is that, and it's a small point, but you tend, when you lean forward, perhaps even a few inches, your head suddenly gets 10 times bigger and you kind of look kind of weird. But also on a more practical level, there are always a number of objectors. When there are objectors, all would need to be connected. And in my experience, objectors to licensing applications tend to be older. I did an application NBAC quite recently where there were 30 local objectors and all very much of the outrages of Morningside variety. I think the average age, I'm not being funny, was about 75. And I think one or two of them had the year trumpets. That's just to give you the idea. So I thought that it is unlikely, if a hearing was to be convened by video conferencing, that a great many of these would be able to work the necessary technology. So that's a practical thing, but I think it's unlikely that remote hearings will survive the present crisis, at least in respect of contested applications. So far as premises licenses are concerned, there have been various changes made. These are broadly sympathetic to the trade in these difficult times, and it is a very difficult time for license trade. One interesting one concerns premises which sell food, where they hold an off-sales provision. Now, many of you won't know this, but even very posh restaurants may hold an off-sales provision. And the reason for that is that if you order a very expensive bottle of wine and don't finish it, you might want to take it home and finish it there. And if that's the position, you cannot do that unless you hold an off-sales provision. That doesn't affect me. I've never bought an expensive bottle of wine. I've never not been able to finish it, but it will happen in certain cases. Where that is the position, and I know what's happening now is a number of restaurant premises are selling off their stock and delivering it to a premises. In effect, they're using their premises and off sale since they can't open. Where that happens, the license is deemed to be altered. There's a condition put in that you're allowed to deliver food or to sell food for consumption off the premises. So what you might find is that we're now getting a situation where even quite posh restaurants are able to sell drink and food for consumption off the premises. And I wonder if that'll alter the way that the business models of some premises. Provision also is made for personal licenses, and that includes the extending of the length of a personal license and also the extending of the time for required training. And there are various procedural changes, usually along the lines of allowing for the extension of times for documents to be lodged by various parties, including Chief Constable, and also for the functions of the board to be exercised by a committee of not less than 3. There are various changes to licensing regulation regarding timetabling for various hearings and also providing for where a clerk, for any reason a clerk cannot issue a statement of reason on time in the prescribed period because of a reason related to coronavirus. The clerk must issue a statement of reasons as soon as practicable. Well, since in my experience, a small number of clerks very often have never issued a statement of reasons time in their life. And whereas as there is no sanction for failure, I see no reason for this. On the ground, word from my sources is the vast bulk of premises are observing the ban, but I'm aware of at least one premises where the license holder apparently misinterpreted the word lockdown for lock-in. And he had a number of his regulars surreptitiously come in the back door, and it was pretty well business as usual. It was like a speakeasy during Prohibition. He should have been aware, however, that the police are operating normally, and there was a kind of Elliot Ness style bust, and that will undoubtedly be a case which will appear before the licensing board in due course, where the license will be held for review. But my message to you, a very brief message, is if you have a licensing problem and there is a difficulty caused by the current pandemic, go to Schedule 5 of the Act, and that is probably contain the answer. If it doesn't contain the answer, then phone Terra Firma. So thank you for that. And with that, I'll just back to you in the studio, James.
Thank you, Robert. We have had only one question so far from the participants, and we put that up on the slide on screen. And you can see that it relates to asset transfer. And I was going to, because we've got only one question and 5 minutes or so left, I was going to ask each of our speakers in turn to consider the question as applied to the subject they've been talking about, and to give us their views about whether it's reasonable for local authorities to shut up shop during the crisis or not. And so in terms of planning, not just necessarily planning inquiries, just over to Maurice first for his short view on that. Thank you, Maurice.
Thanks, James. I think the thrust is coming from above, and it's also profession-wide as well. And the thrust is basically, insofar as it's possible, functions must continue. So it wouldn't be reasonable for local authorities to put everything on hold. And I think that there has to be a time when we'd have to say that even if there's no more lockdown, there will still require to be business done, even if people are social distancing. And eventually, these particular nettles will require to be grasped. And I think that's really the bottom line, essentially, for local authority functions. Over to you, James.
Thank you. And Fred, do you have a view in terms of your subject matter? Obviously, in terms of social services, there's a very much continuing function at the moment, but over to you on that.
I think it's worth remembering that a lot of local government decisions are about individuals, and a lot of these duties and varied duties, well, they still exist. Decisions still have to be made. And having spoken to a few people in the sector in the last few days, obviously at the moment one's sort of slightly doing this by the seat of one's pants. But as this becomes a long tail until we have to wait till a vaccine, it's going to, I think, be a burden on often quite junior decision makers in authorities to ensure that decisions keep being made and that things aren't allowed to lie, because backlogs can build up. And we all know in a winter, for example, how much a backlog affects delayed discharge and other social care related problems. So it's not an excuse, not that it's really an excuse, it's not, one shouldn't try and just stop. There has to be an attempt to clear at least some of the backlog as we go.
Thank you, Fred. Peter, to some extent we've had your view on doing nothing as an employer, but do you have some further words on this?
Yes. Speaking first of all, just in general terms, hopefully when we are out the other side of this present crisis and the dust has settled, I suspect there'll be a lot of re-examination of what decision makers did, what local authorities did, and what other decision makers did in the administration of justice, to see if it was appropriate, if it was truly a response to the crisis, or perhaps just possibly whether it was done in bad faith or not. But moving on from that, in the area of employment law, I suspect tribunals and EATs will be quite sympathetic to employers, except insofar as their actions impinge on safety, and also where they may be discriminatory, and in particular, I'm concerned about disability discrimination. Thank you, James.
Thank you. And I don't know whether, Robert, the schedule to the Coronavirus Act that you suggest has the answer to all licensing problems has a help on this, or whether you want anything further to add.
I think very briefly, the only asset that transfer I would be interested in is probably the transfer of a license. And of course, I see the vast majority of those will be uncontroversial. And although the premises can't open or can't operate except in the very limited circumstances that we have described, I see no reason why that can't be done, because a lot of businesses, of course, are smaller and medium-sized businesses are restructuring just now, and they will wish their assets to be transferred to suit the business, which they will operate following the lockdown. I don't see that should be a problem for the local authority.
Thank you. For my part, a lot of local authorities have stopped having meetings, stopped having any form of committee meeting, and are presumably relying on emergency powers within their constitutions. And whilst there's no general exception to allow them to put things on ice pending the end of lockdown, in my view, courts are going to probably be reluctant to be too strict on local authorities, particularly in the early stages of lockdown. But as social distancing and other factors continue for some time, I think courts will be less reluctant to ensure that local authorities are at least attempting to take all reasonable steps to fulfil their various statutory functions across the board. And the leniency that may apply in April and may well not apply in August and September. So I don't think we've had any further questions. We've managed to get to the end of the talk almost on time. Thank you to all the speakers. Thank you to all of you who've attended. As I indicated at the outset, here are the contact details, which no doubt you're probably well aware. Have a very good remainder of the day, and from all of us, please stay safe. Thank you very much indeed.